My name is Jules Epstein. I'm professor of law at Widener University School of Delaware and director of its Tayshoff Advocacy Institute. A lot of attention is being focused on Florida and the trial of George Zimmerman, what's called the Trayvon Martin case. But I actually have to stop there. It's not the Trayvon Martin case. It's the trial of George Zimmerman. The shooting of Trayvon Martin caused us all to think about a lot of issues: race and racial profiling, the good or the bad of stand your ground laws. And those are critically important policy issues and human issues. But the proceedings that are beginning now aren't about that. They're about one trial for one person accused of a crime. So if you're going to watch this trial, don't expect it to answer great socially important questions. The trial's focus is much narrower, and it's built around the peculiarities of Florida self-defense law, which has a stand your ground aspect and a general self-defense aspect. In plain English, people may use self-defense, including deadly force, when they reasonably feel their lives are threatened. In Florida, you may reasonably use force, indeed deadly force, when you reasonably believe that a serious crime is going to occur and you don't have to retreat. Please note the words reasonably believe. It doesn't say you have to be right. It says, looking at the circumstances, it has to be reasonable. A defendant in Florida does not have to prove beyond a reasonable doubt that it was self-defense. A defendant simply has to raise evidence from the government's own evidence or from defense witnesses that support a claim of self-defense, and then the jury has to look at the charges and say, in essence, has the government really proved its case beyond a reasonable doubt, or do we have a reasonable doubt because it looks like this might have been self-defense? Physically, we have a problem in figuring out what happened because there's no videotape and there's no real audio tape except for a brief 2-second portion of a 911 call. There's a lot of background noise. Maybe 2 seconds you can hear the voice of either Mr. Martin or Mr. Zimmerman, and even whose voice it is a matter of dispute. We don't have an eyewitness to say, I can walk you through this step by step. We have a dead young man, and we have Mr. Zimmerman with some injuries, photographed, medically documented injuries. And we have a law that says it's not a violation of self-defense principles to walk up to somebody and say, hey, what are you doing in this neighborhood? So the question in this case is not going to be, should Mr. Zimmerman have thought, maybe I should back off and wait for the police? It's not was he wise. It's whether there was self-defense as defined by Florida law.